Brad Williams, Labor Compliance Group newsletter, civil wage penalty assessment. I'm not a lawyer. I'm not giving any legal advice. Here we have a case against Sid Blackman Plumbing, and we have some dates here. October 20th, they did some work at Seeley Elementary School. $16,000 penalty for what? DIR stating failure to bring on apprentices. So let's take a look here and see what's going on. We have this normal is there timely this and timely that? Yeah, the issues here are whether OSBP submitted the required contract award information, whether Blackman employed apprentices in the labor classification, whether Blackman is liable for penalties, etc., etc. And in the end, it looks like there were 552 violations at $30 a piece. Project award advertised in 2018. Again, as I keep stating, look at these dates. 2018, this penalty is 2023. For you as the GC, as a sub, do you keep records? If you don't keep records and here you have a penalty, you're going to remember this project? You're going to remember the details? You're going to remember your employees? No. Take my compliance course and I'm going to explain to you how to do this correctly. The work consists generally of, but is not limited to, construction of 12,000 square feet gymnasium. OSBP entered to the contract in the amount of $196,000 for the plumbing scope of work. Contract amount was later reduced to $185,000. OSBP had workers on the project June 13th through December, so for 7 months, a duration of 552 days. OSBP performed work on the project 61 of those days. Keep in mind, there's got 552 days here. Public Work Complaint. Again, we have this Labor Management Compliance Council. Who are these folks? Are they a federal joint management council? Prevailing wage rate determination. OSBP employed journey level laborers and plumbers on the project. Prevailing wage determinations at issue in this matter are that of laborer and that of plumber. Both of these crafts are apprenticeable. The assessment found that OSBP failed to submit contract award information to all of the applicable apprentice committees in the geographic area. The requirement is you send out the DAS-142 to all apprentice committee. 3 days before you need an apprentice, you send the DAS-142 to one apprentice committee at a time. You wait 3 days. Again, if an apprentice is not dispatched, you send the DAS-142 to the second committee, and so on and so forth. Unless you do that, you're going to be subject to possible penalties. The assessment is penalties of $16,000 based on 552 violations at $30. Can you believe that? They worked on the project for what, 19 days? And they're going to assess them a penalty for 552. On May 18th, OSB submitted contract award information to Labor Classification AGC Committee. On June 7th, OSB requested dispatch to the AGC Committee requesting dispatch of labor apprentice. All right, so they checked off box 1, checked off box 2. OSBP did not submit the DS-140-142 to the Labor's JAC. OSB contends that it was not required to do so because Labor's JAC is located in Los Angeles County, approximately 200 miles away from the project location. Here's the rule. If DIR says the committee is within the geographic area based on their website, then you have to follow their rules. As reflected in the penalty review, DLSE determined the first and last dates that a journey person worked on the projects. DLSE also determined that the total journeyman hours worked for each classification is 1:5 ratio. As set forth in the penalty, DLSE determined that there were 552 apprenticeship violations between June 13th and December 19th. Following review by the Senior Deputy Labor Commission, the Labor Commissioner assessed a penalty of $30 per violation for 552 violations for 16.5. This was based on OSB's failure to submit contract award information and requests for dispatch of apprentices to all apprentice committees in the geographic area. Their argument right here, it says they didn't think it was in the geographic area, 200 miles away. So again, they go in and they spew that the employee's right. OSB failed to comply with the apprenticeship requirements, section 1777 set forth the statutory requirements governing the employment of apprentices. In general, unless an exemption applies, 1775 requires hiring of apprentices perform 1 hour, 20% violation. Prior to commencing work on a contract for public works, every contractor must submit contract award information to applicable apprentice programs that can supply apprentices to the project. The information shall be provided to applicable committees within 10 days of the date of the execution of the prime contract or subcontract, with no event later than the first day. A contractor does not violate the requirement to employ apprentices in the 1-to-5 ratio if it has properly requested dispatch of apprentices and no apprenticeship committee in the geographic area of the public works project dispatches apprentices during the pendency of the project, provided the contractor made the request in enough time to meet the required ratio. Again, this is vague. A 100-day project, you send out the DAS-140 and the 142 the first week of the project, an apprentice is not dispatched. Well, there's still plenty of time to fill that ratio. DIR doesn't state specifically what this means. Again, there's so many gray areas within DIR's language, including language like this, that interpreting is impossible. It could read that, provided the contractor made the request in enough time to meet the required ratio. Again, a 100-day project, you send out the DAS-142 on day 1 of the project. Day 3, an apprentice is not dispatched. There's only one apprentice committee in the geographic area, leaving you 97 days. There's still plenty of time for that apprenticeship requirement to be fulfilled. Right here, DIR says if an apprentice isn't dispatched, you satisfy that requirement, but then it goes on and contradicts itself because there's still plenty enough time to meet the required ratio. Is the contractor and sub still required to send out that DAS-142 over the next 97 days? Thank you, DIR, for lack of clarification. The record demonstrates that OSBP violated the apprenticeship requirements with regards to the labor's classification because it did not employ any labor apprentices. Therefore, the question is whether OSBP properly requested dispatch of labor apprentices. OSBP searched the DAS website for applicable apprentice programs. When it was awarded the project, results of each search is documented and it shows the 2 applicable apprentice programs for the labor classification. The parties agree that there are 2 applicable apprentice committees, AGC committee and labor JAC. Although ASBP submitted contract award information and requests for dispatch of apprentices, OSB did not do the same for labor JAC. OSB argues that it was not required to contract the labor JAC because the labor JAC is not located in the area of the site of the public works project as set forth, since the JAC is located approximately 200 miles away. Doesn't matter. Contractors shall provide contract award information to the apprenticeship committee for each applicable apprenticeship craft and trade. Contractors who are not already provided. Here, OSB was not approved to train apprentices. OSB was required to provide contract award information to all applicable. Contrary to OSB's assertion that a contractor must use some discrimination and common sense when using DAS website, the DAS regulations do not give OSB discretions to determine geographic area of operations of the apprenticeship committee. The geographic area of operation of an apprenticeship program is defined as the geographic area in which the program regularly operates and trains apprentices. To support this channel, check out my courses. Here we have this great Understanding California DIR Labor Compliance Rules and Regulations. This is comprehensive. This is going to cover the A to Z of DIR in terms of legal compliance. Federal Davis-Bacon FAQs. This is I call it my pocketbook. This is just a go-to. If you're familiar with Davis-Bacon, but there's many questions related to Davis-Bacon, here's your source. San Francisco Local Hire. If you're doing work in San Francisco, you need to review this. Navigating DIR websites, more there than you think. There really is more there than you think. This is a complement to the compliance course. It is an absolute necessity. California prevailing wages FAQ, similar to this Davis-Bacon. If you're familiar with California prevailing wages, there's a lot of questions that you may have answers to, but then there's a lot that you might not. This is, I call it just the handbook of FAQs related to DIR. Federal Davis-Bacon Contractor's Guide. You're doing Davis-Bacon related work and you're shooting from the hip, don't. Take a look at this course. It's going to answer a lot of those questions that DIR is going to mandate. It's going to require upon you. And consulting. I still do consulting. If you want to do one-on-one training, still do Davis-Bacon and DIR related training. If you need a large project monitored, 5 million above, I'll take a look. And if you have questions that you can't find answers to, give me a call, email me. If this newsletter has been helpful, subscribe, give me a thumbs up, hit that like button, check out the links below. And in summary, this company, OSBP, was on the job for 552 days. Sure, they weren't working 552 days, but the way DIR and their asinine requirements from the time the contractor showed up to the end of the project, 552 days at $30 a day. I think this is shameful with DIR. I think the requirements are reckless. I think this entire DIR commission needs an absolute revision. I think it is ancient. I think the penalty system is archaic. I think DIR needs to start helping subs, start helping contractors instead of the other way around. And I think they should abolish this entire program, rewrite it, streamline it so it's 100% front to end from payment to documentation, all driven off of software. But that $25 million that's paid annually by the subs and the general contractors to register with DIR is being wasted, needs to be redirected. But the bonehead legislature here in Sacramento, what can you say? That being said, let me know how you feel. Let me know what you think of this process. What do you think of the civil wage penalty assessment? Let me know what information you need in order to work through these public works projects so you're not being dinged for ridiculous requirements. Brad Williams, Labor Compliance Group. Thanks for watching.